Welcome to the E.A.T podcast. This is episode number 26. I'm your host, Jerry. Tonight, we're going to do a one-on-one interview with a lawyer from the Basile Law Firm. His name is Gustave Passanante. It's just going to be a one-on-one. Russ will not be with us tonight. Russ will be on the next episode, which we will be doing on Friday night. I'm going to bring Gus on the stream, and then we'll get into exactly who he is, what they do, and all that fun stuff. Hey, Gus, how are you? Welcome to the show.
Hey, Jerry, what's going on? Thanks for having me.
So Gus is a lawyer from the Basile Law Firm. The Basile Law Firm has offices in New York, Florida, and Texas. Their website is thebasilelawfirm.com. You can contact them by phone by calling the main number at 516-455-1500. You can also email them at info@thebasilelawfirm.com. Their Twitter handle is @OTC Lawyers. To contact Gus directly on Twitter, his Twitter handle is @GPP_ESQ. And if you want to contact Gus by email, it's gus@thebasilelawfirm.com. Gus, welcome to the E.A.T podcast.
Thanks, Jerry. I guess we'll talk about a little bit about what my firm does and what we do. So we're like a boutique corporate practice. Not a lot of attorneys, but we do big time things. So we have litigation all across the country. Our main focus is we represent small cap companies, micro cap companies that get into these kind of dirty financing deals. So it includes like convertible promissory notes. We also represent some companies in state court over some other alternative financing agreements like merchant cash advances. And then we also have like a transactional side of our practice where we could do M&A work. We'll do restructurings for certain companies to fix their cap table, which is oftentimes destroyed after they get into one of these convertible notes or one of these toxic lenders. And we do pretty much anything corporate. So,
looking up you guys, we got 100 years experience, and it looks like you got a great team of people in the offices you got in 3 different cities. Also saw something about you guys possibly expanding into London and a couple other places as well, Boston and LA down the road, which you guys are expanding. So that's a good thing, right?
Yeah, absolutely. We're growing at a fast rate. We're getting a lot of success, obviously. A lot of the cases that we work on, we're kind of tailing, probably passing at this point, the SEC and a lot of their enforcement actions. And we are, like I said, we're seeing a lot of success. We just had a really huge decision at the Court of Appeals, an argument that got shot down too many times to count, that we just got. And the Court of Appeals, by the way, for people that don't know, it's the highest state court in New York. So we won a decision up there that actually finally classified the conversion discount under convertible promissory notes as interest. So now you can include that in the usury interest calculation, which could declare notes void ab initio and have everybody walk away, right? So if a lender lends somebody $500,000 and that note gets declared void, they walk away with that $500,000. That liability is completely gone off their books. And it's a huge, extremely powerful tool for a lot of our clients. And like I said, that was something that no one besides us and maybe a few other people in the country even believed was correct. And we were just pretty successful there. And like I said, we're doing something similar in the securities litigation field with the broker-dealer registration issues that I'm sure we'll talk about later on in the podcast.
Oh, yeah. But we will.
Yeah. So yeah, we're definitely growing at a fast rate. Hopefully not too fast, but yeah, everything's going well.
And just someone were to contact you, via email, Twitter, however they contact you. If there's something you guys don't do, you guys have relationships in the world where you guys work and everything, that if it's something you guys don't do, you'll refer someone to a company or a firm that handles or specializes in what they need if you guys don't do it.
Absolutely. We have a list of Exchange Act attorneys that we work with that we refer a lot of our clients to because we don't do Exchange Act reporting. We have a bunch of counsel relationships with other attorneys pretty much in every aspect of business, whether it be intellectual property or tax or anything like that. So we try and keep everything that we can in here. But even if we do refer you out, we probably are going to have a really close relationship with that person too. And obviously trust them just as much as we trust ourselves.
Okay. And just a heads up for everybody who's watching and listening, there is a live chat tonight. The live chat is off screen. Gus and I can see it. If you have any questions, you can drop them. We will get to them. But just a heads up, if anybody does ask a question about a ticker or a company that Gus's firm is working with or against, obviously for the obvious reason of attorney-client privilege, Gus cannot and will not comment about that company or anything about the case because he just can't. But everyone should know that anyway. But I have to just say it so we know. And let's get into it, Gus. So the big thing that everyone seems to be getting into lately is that rule change, the OTC SEC deadline that passed at the end of September. It's ruled 15C211. And everyone knew it was coming. OTC companies that weren't pink, that were, I don't know if they're a scam or, that seems to be the wild, wild west, and companies are a scam. And that just seems to be the terminology associated with OTC before this happened. And this rule change was going to weed out all of that. Every company was going to have to show that they actually had product, they actually had revenue, they had facilities, everything that was legit with them, they had to eventually show. And in your professional opinion, was this a good thing? Was this a bad thing? We're now about 2 months into this. As this deadline passed, 2 months later now, how do you look at everything on your side of things and recap it? Was this good or bad?
Yeah. So just to correct you a little bit, Jerry. So you said these companies need to prove revenues, prove operations. It wasn't necessarily that. Remember, they just need to become current reporting. So if they didn't have revenues, they just need to report it. They would just need to report their operations. They just need to become current with their reporting. From my professional opinion, and I don't mean to step on anybody's toes if I do, but it seemed to be a good thing in hindsight. The SEC has been trying to do this. They've tried to do this before. They tried to do it about 20 years ago. Obviously, met with a lot of resistance. And really, like the purpose of the rule was, just like you said, was trying to get rid of those companies that aren't reporting, which to most people should be a positive thing, right? I mean, if a company's not reporting, why aren't they reporting? If you're subject to certain disclosure requirements, make those disclosures, and you're going to be on those exchanges. Obviously, it's buyer beware, especially on the OTC markets. It's a risk that you're going to have to assess when you're purchasing or selling a security on one of those exchanges. It's all emerging growth companies. It's all startup companies. They might not have a lot of history. You might be taking a big risk, but you might end up with a big reward, obviously. But in my opinion, it was good. I think maybe the execution may have been flawed a little bit. I know there was a lot of confusion interpreting a lot of some of the rules in the OT, especially from the OTC markets. There is always going to be a gray area, especially with a lot of like rules that the SEC brings down. That's why they issue so much guidance. But like I said, in my opinion, I think it was all in all a good move. And also, the biggest change here, right? It was, these companies always needed to do this. It's not a new requirement. They were just updating the requirement, right? So the piggyback exception no longer applies. And another another big thing that they changed is now you can no longer pay a market maker to sponsor you on your Form 11 on a Form 11 that they would need to submit to FINRA, which was really the only reason a lot of market makers were doing it. You could pretty much pay to have a public company. You could pay to get publicly quoted. So to avoid that, now these market makers have to go on their own initiative and start and file this Form 11 with a company they know is reporting and a company that they see faith in, right? So if a market maker is not going to do that, then maybe that isn't such a bad thing for a retail investor, and they're not going. Then that stock's not going to get publicly quoted. And the market maker didn't just get paid to put it up there, right? So in my professional opinion, I think it's a good rule, and I think a lot of Exchange Act attorneys would also agree. I think most attorneys would agree. But just a little history, like when Pink Limited or Pink Not Reporting first came out, the SEC thought they were going to finally do away with all the bad companies, and it was a complete backfire. Like the SEC had no idea. Like, oh, cool, we don't have to report anymore. This is awesome, right? That's how everyone reacted. Like, oh, perfect. Now we have an exchange we can sit on and don't ever have to report.
Yep.
And it was like the complete opposite of what they wanted. So sometimes they don't execute things perfectly and don't achieve the goals that they want to achieve perfectly. But I think the idea behind it was a good idea. Like I said, maybe there's a flaw. The execution was a little bit flawed. Maybe there are kinks that could be worked out. But I think all in all, I think it was positive.
Okay, so we got 2 questions in the chat, and that's going to tie into actually my next question. So the 2 questions that are posted, somebody wrote, what if they did report and they're still not current? And then the next question says, what do you know about the backlog for companies who submitted prior to the deadline and still are not Pink Limited or Pink Current? So those two things basically tie into each other. And
Yeah.
the question I was going to ask you was basically, as the deadline came and went, companies went to the pink mark, went from non-pink or yield or whatever they were to expert or gray. Now, 2 months later, we're still wondering what's going on with those companies. So is there a buildup? Was there a buildup and then a backlog? Did they sort through it all? Is OTC saying, hey, they anticipated months and months of a backlog. Has OTC put out anything saying we have this backlog still? We don't have it? What's the current state of these companies that aren't pink yet and you're expecting them to be pink?
Yeah, so that's a really good question. I know we spoke about this earlier too, Jerry. I did all the digging I could do. I wish I had an answer for that. I don't think I do. I don't know why exactly, but I think it could be attributable to what I was saying before and how there was uh, there was some confusion as to the interpretation of the rules. Um, OTC markets never really been easy to get information out of, obviously.
Mhm.
Another thing that we talked about before, Jerry, was that OTC markets themselves are publicly traded, so they need to be careful about what they say, right? They
Yep.
can't just start tweeting things. They can't just say things and go on a podcast and say something, make empty promises. So, I'm sure that there's some thought in that before they say certain things because, I mean, you're dealing with, like you said, a lot of companies just did this. I'm sure they are backlogged. I'm sure they are overwhelmed. And um, I was reading the stat. I think like 2,000 companies got kicked down, and then who's showing up late to the party and who wants to become current right after, and who thought that they were going to make it. I know we got a few calls because I know sometimes we get mistaken for an Exchange Act reporting firm. Somebody's
Mhm.
a firm that would do that. And there are people calling us on September 26th saying, "Hey, can you get this done by tomorrow?" And
Yeah,
so who knows?
sure.
Who knows what's going on? But yeah, it stinks that there's a lot of companies that are stuck in that purgatory. I noticed. I mean, I was on Twitter and I was engaging with some of my followers that were telling me about it. It was the first time I heard about it. Actually, I didn't even realize that there were some companies that became current and complied with everything under the Rule 15 amendment and still
Mhm.
got kicked down and still aren't back up. It's unfortunate, and hopefully that gets resolved sooner rather than later.
So, as you just alluded to, OTC is a publicly traded company. They trade on their exchange, and they are tight-lipped. They can't just come on a podcast and say what they want or tweet out what they want for obvious reasons. But do you think there should be some kind of maybe public information officer or somebody who comes out with these other companies and says, "Hey, company XYZ is not pink because of whatever reason," or company ABC needs to update form whatever, and then we'll be on our way. Is that a way that they should conduct it? Because that's not the way they do conduct it. And I
Yeah.
feel like if they did conduct it that way, the retail shareholder would not be in the dark so much the way they are now, where it's a guessing game. Company could say, "Hey, financials are updated, it's audited, we're good to go, we're waiting on them." And if OTC came out and said, "Well, that's not really the case, we're waiting on A, B, and C from this company, and they're dragging their feet," we
Mhm.
would know. So has that ever been discussed, or would that ever be allowed? I mean, obviously, it would open up Pandora's box, so to speak, about the inside world of things, but it would also give us or the retail investor insight on what actually is going on and what a holdup is or isn't.
Yeah, that's a really good question. To be honest, I'm not sure if that's ever been thought of or considered by the OTC markets. But I do know that just from my personal experience, I know that when, let's say, when like I've had clients that have been trying to, hop up, not necessarily up list, but go from like the pinks to the QB or something. Um, and sometimes OTC takes a little while to respond to them, and they're doing
Hmm.
everything right, and they're trying to do everything right. And they're trying to get guidance, and sometimes they're not so clear in their guidance, but sometimes it's because their guidance isn't so clear with the SEC. Um, and it's I don't know. That's a really good question about the whole like public
Yeah,
voice about the
yeah,
status, I guess, especially in a time like this where there is so much confusion and this could be potentially affecting so many people that have shares in some of these companies that are stuck in that purgatory. That is
yep.
a really good question. I wonder what kind of like reporting concerns they might run into some issues about certain reporting, and then especially discussing not only their own company but other companies too as well. I'm sure the liability probably just outweighs any potential reward that they can get from talking about that stuff.
Yeah, I
So
mean,
that's why it's probably not so public and they're tight-lipped about everything.
Yeah, I haven't had a good experience about them. I've discussed this in the podcast before. I mean, I contacted them asking them to come on the show and discuss the rule and the deadline and everything else. And they basically asked a bunch of questions like who I am, what I do, who the audience is, what our website is, all this personal stuff. And then the final question was, hey, are you guys going to be compensating us for coming on? And that put the kibosh on everything. That was the end of that. I mean, I'm not paying anybody for a guest. I'm not paying a guest to come on the show. If you want to come talk about things and inform the world on, your business or your company or a sector or anything, sure, come on and talk. But I'm not paying OTC Markets to come talk to us, and that put the kibosh on it. They were nice enough to answer a few questions in an email about promotion and a couple other things, but they're very tight-lipped, and they weren't coming on to speak. So I have my own personal feelings about them. But we got a couple other questions in the chat I want to get to real quick. So somebody's asking, is there a reason why other countries, such as Canada, can trade expert market or gray market stocks, but the United States, where the companies are based, the investor is locked out? So basically, like E-Trade or TD Ameritrade won't allow you to buy XYZ company that's gray or dark. Why can you do that in Canada? Do you know?
I have no idea. That's a really good question. There might be certain laws that apply in Canada that might not apply here, but I'm not sure. I've never never experienced that one.
Yeah, I
Like
think
I said, I do litigation, so if you want me to, what was that?
The only brokerage that I think allows you to do that is like Interactive Brokers, is what I've seen. I mean, there's not even that many that allow you to trade these stocks. So you look at
Right.
XYZ company or ABC
We're
company
already
that's gray right now.
Mhm.
The volume in a day is like 3 million, and that's only because it's based on a foreign buying and selling. It's not even U.S. based.
Right.
It's just not happening.
Yeah.
But there's got to be an SEC law or rule or something in place that we
There
just don't
might
know
be.
about.
Yeah, I mean, there might be some. Who knows? I mean, there could be something. There might be, Canada's version of the SEC, whatever that is. I have no idea. They might have some kind of exchange enforcement agency or something. And yeah, I'm not sure. It's a good question.
So, I mean, obviously, in the world that we trade in today, CEOs and social media seems to go hand in hand, and I guess it's easier to just drop a tweet as opposed to putting out a full PR. But so a company can go on social media, whether it's Twitter, Reddit, Facebook, wherever, or even a podcast like mine or anybody else's, and they'll say we have an endorsement deal coming down the line, a week from now or whoever. It's going to be XYZ athlete or singer or whoever. We can't tell you who, but it's in that area. And then a few days later, a few months later, there's no announcement. There's nothing that happens. Or company comes out and says, hey, we got a retail distribution deal with a big retailer. And, they'll imply it could be like a big supermarket or, Amazon or a big online retailer or somebody. And then nothing happens. So these companies put out these statements. Nothing happens. Obviously, the share price goes up through the roof. You and me, who's the retail trader, will buy the stock based on this news because you think something big is coming. And now nothing comes, months later. And basically the stock price now has dropped beyond what you bought it at. You're quote unquote holding a bag and you have nothing. You're sitting there at a loss. What rights does a shareholder have at this point where you were basically sold on a bill of goods and it never came to fruition and now you're at a loss?
Yeah. So in that scenario, that's just plain securities fraud. So a shareholder would have to, commence an action for securities fraud against whoever made that statement and how they made that statement. Security fraud is tricky for a few reasons. Obviously, it's expensive litigation, right? So if you don't have a huge case, if there's not a huge pool of damages, there wasn't a lot of harm that was caused, no one's taking that on contingency, and you got to lay out the cost yourself. And sometimes maybe the costs might not be worth the reward at the end, obviously. So basically, you'd commence an action. You'd allege that they made a material misrepresentation, which in this scenario like that, right? Somebody comes on a podcast and says, "Oh, I'm going to have Odell Beckham Jr. sign on to this brand," right? So some kind of brand for something. And they do that, and they're a publicly traded company. That's obviously a material misrepresentation. As long as they know, and then another element of securities fraud is that this mental element of it. So the person making that statement needs to know that what they're saying is false. Know and intend to make this statement that it was false, or you need to allege some kind of motive for them to make it false, right? So sometimes if they make these statements and they're, let's say, talking to somebody, or like they might have been able to get that person, they weren't
Mhm.
necessarily lying
Okay.
sometimes, right? And sometimes they'll tiptoe around what they say, and you'll notice that a lot of times, especially CEOs, like, on Twitter or something, right? Like they're not gonna, they could use puffery, they could kind of sell themselves a little bit and be salesmen, right? And say things,
If
but it
a
needs
if
to be obviously material, and needs to be a fact. So what was that?
if a company comes out and says, "Our intention is to do this."
Yeah.
Sure. I intend for my podcast to have 1 million listeners every week. I know
Right.
that's not happening.
Yeah.
This is just a hobby and it's fun for me, and it
Yeah.
is what it is. But my
Yeah.
intention is for this to be the biggest show in the world.
Right.
It's a great statement. And a
Yeah.
CEO could say that too. They intend for their company
Right.
to sign this big deal, have
Exactly.
these big revenues, and that's their intention. But hey, you know what? Anyone can intend to do anything. That doesn't mean it's
Exactly.
going to happen.
Exactly. Exactly. That's a perfect way to put it. Yeah, that's how they tiptoe around what they say. I mean, securities fraud is hard. It's always been hard, really hard. Like I said, it's super expensive, really hard to plead. There's a crazy stat out there, because any fraud action, it needs to be pled, and pled
Mhm.
by pled I mean, what's stated in the complaint. The complaint just consists of the allegations that's going to set forth a cause of action, right? So it's just facts. What did this person do? And you need to be able to put them on notice of which parts of their conduct that you believe entitles you to something, right?
Okay.
So when you have any kind of fraud action, whether it's a common law fraud, wire fraud, securities fraud, whatever fraud it is, you're subject to this heightened pleading standard in every single federal court, and I'm pretty sure in every single state. They have similar requirements under like their procedural rules. This heightened pleading requirement makes it very, very difficult to withstand a motion to dismiss. Very, very difficult. Like like I said, there's this crazy stat. I want to say it's around 70% get dismissed. The ones that do stick, they're amended 4 or 5 times, right?
Okay.
They get dismissed 4 or 5 times, and the 5th one sticks because they were able
Yeah.
to plead it right. It's very, very hard to do. Um, Granted, I'm not saying it never happens, but usually
It's few and
it's
far
it's
between.
very difficult to do. So that's another reason why a lot of firms aren't willing to take on that kind of work. So unless you have an open and shut, something that that you could plead, no
Mhm.
one's going to put that kind of effort into just a complaint, right? No attorneys are going to do that, and especially if the pot isn't that big at the end. If
Yeah.
you only have, like, I think, and another thing we discussed was about all of these OTC companies, right? There's not a lot of people that are invested in these stocks. There's not a lot of money that, I'm not saying that your harm doesn't matter, but if your pool of harm is only $1 million, but if the pool of harm about somebody, Elon Musk making some kind of misrepresentation, the Tesla shareholders, right? The market
Yep.
cap gets destroyed,
Destroyed. Yep.
and somebody and all those shareholders, they have a pool of $600 million that they could
Yeah, and you
potentially
got
get.
hedge funds and everything else involved. It's not
Yeah,
just the regular retail guy, hitting
exactly,
you at OTC.
exactly, yeah, right. A retirement fund, yeah, exactly.
Yeah.
All, yeah. So there's just a different. It's just like a different game, especially on the OTC markets. And not only that, I mean, those are just private remedies. I know somebody in the chat just said, what's the backlash? But the backlash is,
Yeah.
of course, the SEC could always go out. Of course, the SEC always has that opportunity. But another thing that we discuss is it's the SEC, right? They're not. There's 11,000 companies publicly traded, or something like that. There's some outrageous number,
Yeah.
not outrageous, but there's a lot of things that they would need to watch, right? The SEC just doesn't have the resources to enforce every single wrongdoing. They just
Yeah.
don't. It's just not possible to cover every single time something goes wrong. And when something does go wrong, it's going to be, oh, okay, who are we going to focus on? That Nasdaq, those Nasdaq shareholders, the shareholders of a company that traded on the Nasdaq that lost $600 million due to some kind of misrepresentation or some kind of fraud, let's say, or uh, the shareholders of some company trading on the pink sheets that has a
Yeah.
market cap of $11 million, and the total harm was like $500,000, right? So they're going to go obviously to the biggest fire and put that one out, and
As as bad
it's
as that
hard.
sounds, though, because people lost money
Yeah,
either way, whether it's 600 million or
100%.
half a
Yeah,
million,
no,
someone lost
I'm
money.
not, absolutely. And that I'm not discrediting those losses at all on the OTC market.
Yeah.
I mean, that's what I do. That's my job. I
Yeah.
represent those, I represent those companies. I see it all the time. And they're, like I said, they're lacking enforcement. That's why they're firms like mine. And there's not many firms like mine. We're one of the only firms that do this in the whole country, that do what we do. And it's for that reason. There's not much money in this,
Hmm.
unfortunately, sometimes, right? Like, if they could foot the bill for a little bit, and then sometimes it just gets to a point where they can't fight anymore because they're going up against a way bigger fish,
Yeah.
almost every single time. So it's tough. And of course our clients are fighting, like they're going to fight, right? And that's why we kind of not selectively choose our clients, but like we tell our clients, like, hey, you're not hiring us to settle. We're going,
We're
we're
going.
taking this all the way. We're going to see what, like, we're not, you don't hire us to settle. You don't hire us to send a letter and say, hope that we get out of this in the right way. Like, we're building a reputation like that. Um, so it's tough. There's a lot of factors, and I could talk about this probably all night, but yeah.
Okay. Keeping with the social media theme, uh, you have influencers. You want to call them pumpers. I mean, people have words for them. There's Discord chats. There's Wall Street Bets on Reddit. Like you just said, the SEC is going after the big fish. But you get a group of people big enough. Wall Street Bets is what, 12 million people or 13, whatever it is now.
Yeah,
I haven't seen it in
absolutely.
a few weeks, but it's huge. So you get a group of people like that involved, and you start buying and selling or playing options or shorting or whatever a company. GameStop for argument's sake, or BlackBerry or Nokia or any of those other ones that were on that list. You see the price action go through the roof from $7 to 400 and whatever it was. Obviously, it's got to get the SEC's attention, right? I mean, they know what's going on, but should they be doing more, or is there stuff going on behind the scenes that we just don't see or hear? No one's leaking anything. Like, what's the
Yeah,
SEC doing with all of that? Because you get 15 million people in a chat room on Reddit, they're gonna, manipulate or influence a security or two.
yeah, absolutely. The the thing is with the SEC and pretty much any federal agency, they're very, very secretive. Like, I mean, you
Hmm.
don't know what they're doing, right? And they'll investigate something for a year before they commence an enforcement action,
Okay.
and investigate for 2 years. Um, a good idea, something that we do, is we put in a lot of FOIA requests against some of the hedge funds that we deal with, and um, and they'll respond. Either they'll respond and say, "Hey, we have no information," or they respond and say, "Hey, we can't give you any information we have." Right?
And at
One of
that
them
point, you know
implies something,
something.
the other one doesn't.
Yep.
Okay, yeah. So you know where I'm going with this.
Yep.
They're going to be very secretive, but just because they're being secretive doesn't mean they're not doing anything. Um, they work hard. They work a lot, and the people that do that are pretty passionate. I mean, I deal with the SEC a lot on some of the broker dealer registration issues that I discuss, and we work hand in hand. Like, we're always talking to people from the SEC, out of the different regional offices, depending on where the hedge fund is or the lender is that we're dealing with, or that we're,
Hmm.
instituting litigation against, or defending one of our clients against. So we do work a lot with them, and they're swamped. I mean, they can't even breathe. They say every single time they can't even breathe. Like, all right,
I can
thanks, guys.
imagine.
But you sent us 15 other ones last week. We'll get to it when we get to it. And that's just the stuff that we do, and like I said, the stuff that we do in the OTC markets. We were talking about this earlier, Jerry. It took almost 10 years for these convertible notes to start getting, for the SEC to kind of get wind of it and actually start devoting resources to it and say, okay,
Yep.
this is really a problem. Let's do something. Hey, like, I mean, they're executing these notes. They're acting as dealers. They're not registered to do it, and something we'll get into more later on.
Yeah,
Um,
we will.
but yeah, it's tough.
Now, one of the biggest things that hit, FinTwit or financial Twitter, however you want to word it, lately was the Alex DeLarge, whose real name is Stephen Gallagher, his arrest. So it came out a few weeks ago that he lives in Ohio. He's got 70,000 Twitter followers. He was charged with securities fraud, wire fraud, and market manipulation in a Manhattan federal court. Basically used his Twitter handle, which was Alex DeLarge, and the suit alleged that he earned over $1 million in profits, while many of his followers were left holding a bag. The suit continued to say that he made false and misleading statements. He engaged in a series of transactions designed to artificially raise the price of a share, the share price of a stock, well after he was out of it. So, XYZ company he bought and told everyone about it. Now as the price is going up, he basically sold it and left people holding a bag. deceptive practices and all this other stuff that was going on. When you see something like this, does it make you cringe? I mean,
Yeah.
obviously this is happening a lot more than we see.
Yeah.
Not everyone and their mom is getting arrested for these crimes yet, but it can happen tomorrow or a month from now, whatever. I'm sure it's being investigated. But when you see something like this, where the guy makes $1 million and now, X number of, Twitter followers or whoever are left holding a bag and crushed, does it make you cringe? What are your thoughts on that?
Yeah, of course. I mean, this is I guess it's just the day and age that we live in, right? I mean, when you could build, build a network, or maybe not a network, but build a following out of your house, right? And
mom's basement.
mom's basement, and obtain influence over as many people, 70,000 people that he was able to influence.
Yeah.
I mean, how could you stop that? Yeah, how could you preemptively stop it? I'm not saying there's nothing you can do afterwards, right? And it's always nice to see the SEC jumping on things, especially like this. They're so current and going after disgorgement and the profits that he made. So that's one thing. I don't know if a lot of people know, the SEC has a lot of different powers than private litigants do. The SEC has way more power than anything I could assert on behalf of my client privately. One of those big things, which is what they're seeking in this lawsuit, is disgorgement. So they could obtain all the profits that he made. A private litigant can never do that.
Okay.
Can never obtain the profits that he made. You can you can obtain the harm that you were caused, but the SEC can go after everything, right? So they kind of drop a little bit heavier of a hammer than we could drop. A private litigant could drop.
They're basically freezing your bank account, taking your house out from under you, taking your cars, taking your boats, everything else, and you're basically in a cardboard box, in the middle of the park.
Yeah. No, yeah, they don't mess around. Yeah, they'll freeze your bank account 2 days after they slap you with the lawsuit.
Yeah.
They do not mess around, yeah. But it is, it's good that they're taking action on it. I think it's important to stop, especially this stuff on Twitter. I mean, it's getting almost out of hand. I see stuff. It's constant, right? I mean, I'm not even really in the space as much because I go on Twitter to interact with people in like a very kind of like limited scope. I mean, if people are trading off of information they're going on, seeing on Twitter, which I know a lot of people do, and a lot of people are, it's, I mean, that's
a lot of people are doing it. And, I'm not going to mention names. I don't even want to, but there are people out there that have 2, 3, 4, 500,000 followers. They have a chat room on Discord with 300,000 people involved, and these things happen. I mean, you see it. If you're a part of it, it's out there. The SEC has to be aware of it. It just has to be. And people are posting pictures on Twitter. They're in this house, they're on this boat, they're on this vacation. That what's going on. You know what they're doing. It's only a matter of time till these guys get caught.
Yeah.
Everyone's going to get caught eventually. It's just a matter of time.
Absolutely, yeah. Matter of time.
So let's get into fraud, market manipulation, dilution. This is a hot topic. I mean, you put out a couple of tweets. The law firm itself put out a couple of tweets, and it kind of caught a little bit of fire. But what can you tell us about it? And I know it's a lot. So market manipulation, dilution, market makers, counterfeit shares, convertible notes, toxic debt. I mean, there's a whole way to go about this. I mean, we could talk for an hour just on this alone. But what can you tell us about it? So market manipulation, it happens. It happens out there every day. What is a sign of it? What should you be looking out for? How do you avoid it?
Yeah. So what we my firm litigates a lot of is these broker-dealer registration cases. It's really complicated. The main takeaway that I think retail investors should know is that it looks like market manipulation. It looks like counterfeit shares. If you see trading volume just spike for 3 or 4 days and then just go back down, all of a sudden the outstanding shares increased by 600 million shares out of nowhere over the span of 3 months or 4 months, there's probably something going on, right? And I think a lot of retail investors, at least from my experience and engaging with followers and people on Twitter that I discuss, try and discuss this stuff with, it's a lot of people get this idea of them being counterfeit shares. So to understand the security, a convertible note, let's say it's a security, right? A lender or a hedge fund, right? They'll purchase this note from an issuer, usually an OTC issuer, at least the toxic ones, right? With these steep discounts to market, floorless convertible, cashless conversions under warrants and things like that. Just repulsive agreements, like seriously repulsive. That's like the best word to use. to describe them. And so when that hedge fund or that lender will purchase the note, they will acquire debt from the company, or the whole debt of the company. I apologize.
Mm-hmm.
The whole debt from the company. And the way that they get that debt repaid is by converting the debt into stock. They convert that debt into newly issued stock. Every time they put through a conversion notice, new stock's coming out of the reserve. So there's new stock entering the market every single time conversion notice is coming out. Not only is new stock coming out, it's not coming out one-to-one. They're converting it with a 40, 50, 60% discount to market based on the 3 lowest trading prices of the preceding 20 trading days prior to the notice of conversion that was submitted, right?
Which is
so
crazy.
Whatever a lender might do, yeah, exactly. So discount to market really might be more than 20% the day that they get the conversion. What a lot of people might do, and if they get get a hint of like, oh, hey, there's going to be a lot of shares in the market soon. Like, what's going to happen, right? What happens when there's a lot of shares for sale? It's going to plunge. Okay, what does everyone want to do when it plunges, right? They want to take short positions. Just because
then you get more shares at a cheaper cost. I mean, look at it.
Exactly, because
it plunges and plunges and plunges, and instead of you getting the original deal that you thought you were getting,
right,
you're getting a better deal at the cost of all this money that just crashed.
Exactly. So that being said, that in itself might be market manipulation.
Mm-hmm.
I think that there's a good shot that you could probably state a claim for market manipulation based on some of the kind of personal thoughts that I think that these lenders do, just because of the mechanisms, the conversion mechanisms. Like, why wouldn't you take this position? Because then you're going to make $10 million on a $50,000 financing. So that's
heck of a return.
Yeah, right. That's what I would do. So I think that would probably be a sufficient cause of action to state. What I think, though, and what my firm, the position that we take is dealing with this broker-dealer registration, or lack thereof, really.
Mm-hmm.
So engaging in this practice, buying, selling securities for your own account, you're acting as a dealer, right? And when you're doing this to 80 million shares every 2 weeks, to 15 different issuers, you're a dealer. And you need to register as one. And you need
to be licensed, insured, like driving a car. You need to have your affairs in order.
You need to be getting watched by, like, FINRA needs to have an eye on you. The SEC needs to have an eye on you. That's what dealers have to do. So, and I just want to kind of track back to what I was talking about earlier, fraud. And remember how I was discussing fraud, and fraud has a heightened pleading standard. So does market manipulation. So it is kind of hard. It's a little bit easier to plead market manipulation because you don't have to necessarily plead facts that wouldn't be known to the plaintiff, right? So if they're taking short positions, you'd never know what their trading records are. So you could just plead that they're taking short positions. And you could plead that they're influencing the market. And you could just point to the contract to allege scienter, right? Because if you know their contract's market adjustable, the conversion mechanism is market adjustable, and there's a discount to the 20, let's say a 3-day average. And these are all slightly different, by the way. Sometimes these terms, it might be the 15 days preceding, it might be the lowest price instead of an average of the 3-day. So they're all a little bit different sometimes, but they're all mostly the same for the most part. The substance of them are the same. And when you make that allegation, you need a little bit less information. You need to be a little bit less specific, right? Because you can only plead the information that you'd have access to. So it's a little bit easier, but it's still heightened. When you plead a violation of, for example, Section 15A of the Exchange Act for somebody acting as a dealer or engaging in securities transactions as a dealer, and they're not registered as such, that's just a regular cause of action, right?
Yeah.
And then there's relief that's allowed under the Exchange Act. There's Section 29B, which allows for private litigants to obtain relief, either void the contract as a whole or void the rights of the enforcer, right? So on the defensive side, right, you kind of put up a shield and say, hey, you can't enforce this, or on the attack side, you try and void it. So whether our client's a plaintiff or a defendant, we have a little bit of a slightly different position, but the arguments are the same. You're acting as a dealer, you're engaging in these securities transactions, you're acquiring shares at a discount to market, you're selling those shares right afterwards. You're purchasing the promissory note itself. That's a securities transaction. Convertible note's a securities transaction. That's a security. You're
Mhm.
purchasing that note, you're converting under it, you're selling under it, and who knows what they're doing in between, right? And there's really, like, you know what I mean?
Hopping on
So
flights to Vegas for all we know.
exactly, yeah. So that's the position that my firm takes, and we think it's a really good position. Um, and it pains me to see all of the shareholders I interact with on Twitter because I can't really stick up for them because you don't have, a shareholder might not have standing.
Mhm.
Although, so kind of side note, Jerry, I do want to mention this for anyone on Twitter that might be watching. There's my firm did actually post a press release and have a Q&A, and we posted on Twitter and we put out a lot of feedback because we were actually interested in possibly gathering, trying to certify a class for one of
Okay.
these manipulation schemes that we believed was going on.
Mhm.
And when we put out feelers, I mean, we shared it to all of our Twitter followers. I think we had like 4,000 followers on Twitter or something on the firm's Twitter.
Mhm.
There's a lot of people that we got it out to, and we got a dozen responses. And out of the dozen, we had 5 people that actually were able to um, express some kind of harm that was caused to them.
So that
So we
wasn't a
did.
successful thing.
It wasn't successful, which is why we
No.
never moved forward with the investigation.
Yeah.
So I just wanted to kind of bring that up, so because I do see there's a decent amount of people leaving comments on the side. So
So
if we would
the
do
the
that
comments that
again,
are there, yeah, I mean, they're talking about specific tickers, which some of them I don't, for my own reason, I don't want to get involved in because I don't know if your firm is involved in them or not. I mean, you can see them. I mean, if you want to point out a ticker or two that you see that you can talk about, great. If not, I don't want to bring it up and then have you say, "Oh, I'm working on something with them," and then anyone could be
right?
tipped off that you're
Yeah,
doing something. So I mean, you see the few tickers that are being
yeah.
mentioned
Yeah, I
in
see
in
the
the
tick.
chat.
I was just talking in terms of just volume. I just see a lot of people kind of messaging, and I wanted to just put that out there. We put feelers out there, and we're not opposed to trying to certify a class and commencing a class action against one of these people. Because, like I said, I think we're talking about this before, Jerry, and these manipulation schemes. I mean,
Mhm.
I think they run far and wide. Right, a broker's
Oh
going to
yeah.
know what's going on, right, when they put that conversion notice in, and who knows what the broker's going to do, right? A market maker might notice, oh, hey, there's conversion going through, right? They have 3 days to clear. Okay, what are we going to do in those 3 days? What do you want to
You know
do?
what they're gonna do. You know what they're gonna do in those three
Yeah,
days.
exactly.
They're gonna tell their friends, and
Yeah,
you know what's gonna happen.
right. Exactly. So that's what I think. It runs that deep. Who knows? I mean, we've
Okay.
never gotten. I've never gotten to uncover any of that stuff. But yeah, I absolutely believe that that goes on, and we're absolutely willing to certify a class. But last time we did, we tried to do that. We just didn't get a lot of feedback. So that's why I just kind of wanted to bring that up. I saw there's a lot of people here, and if we do put out something like that again, I would love for, a lot of the people that I engage with on Twitter to interact with it and try and put
Mhm.
it together. We need people. If we can get people together, we're absolutely not opposed to investigating for a class action based on exactly what I'm talking about today,
Okay.
because I think that's where it's rampant, especially on the OTC markets, especially with the bunch of tickers that I see right now. I'm
Yeah.
not going to say specifically, but absolutely, there's some of these tickers are getting annihilated by these toxic debt holders.
So a question that is in the chat is: what do you foresee as a typical time frame for a company to have toxic debt removed/reversed? Is there a typical time frame for this to come to fruition, or no?
I think that's a kind of hard question to ask. It's a pretty fact intensive question to ask, and by that I mean it kind of depends on the scenario. Um, there are times that we'll get engaged and the lender wants absolutely nothing to do with us and they
Hmm.
fold. So, I mean, that's happened to us before and they've walked away in literally 3 days and nothing. We got our client out of a couple $1 million liability. And it was just because the reputation that we have, right? Because we're not here to settle. We're here to,
Yeah.
yeah, we're here. We're not here to settle.
Yeah.
So it really depends. I mean, if you go through litigation, it could be years. There's no telling. Uh, there's no telling. And for a lot of these people, they're not fighting for this case. They don't care about the money they might lose here. They care about
Hmm.
their business model, right? So the
Yeah.
precedent that this case is going to set, it's worth more than the 200 or $300,000 note that they might have bought. It's worth way more than that to them. So they have no problem spending $1 million on litigation for a $200,000 note. And it might sound crazy, but in reality, this is how they're making hundreds of millions of
Yeah.
dollars.
The $1 million and the
Just
200,000
one,
is nothing down the line.
and they
The
will
rain
go out
at the end of the
and
rainbow, it's $100 million or whatever it is.
they will go out and hire the most expensive law firm that they could possibly find. That law firm will put out publications discussing the issues, right, and try and garner public influence. And they will do everything they can.
Mhm.
It's way deeper than just the case at hand for all of these lenders because they don't do it one time. They don't do it two times. So
They do it
it's
over and over again.
yeah, yeah. So it's big to them. So if you run into somebody like that who does this is their life, they're gonna fight tooth and nail. Even if it's not a big note, it's not a big financing, they will absolutely fight. And also, it depends. A lot of clients that I deal with, at least, there's a lot of them have a lot of convertible debt
Mhm.
because they'll enter into these financings. In general, the same lender will be like the next month, be like, oh, hey, you want another 100 grand? You want another 300 grand? Same terms, cool.
Cha-ching.
Yeah,
Cha-ching.
exactly. So okay, so something that's relevant to this, there's something called Rule 144, and it deals with the sale of exempt securities, right? So they can't sell any of the stock that they would acquire through a conversion for 6
Mhm.
months.
Okay.
So you'll know this is the telltale sign. If that stock, if a company that you have shares in, if their stock all of a sudden the volume starts acting funky after 6 months and 1 day, you know for sure that it's convertible debt that's on their books. Go into a filing and go find it. Go find that convertible
If they
debt.
have filings. If they don't have filings and they're not
Right,
reporting, then
right.
you're not gonna see that.
Exactly. 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 But yeah, that's a telltale sign, right? Because they wait 6 months, convert it, sell it,
Yeah.
and
And cash out.
scot free, making whatever they want, right? So they try and get into as many financings with that company before the 6 months hit, before the company realized, like, oh, wait a second, we're not going to survive this. This isn't
Mhm.
going to there's no way we could sustain that kind of volume. There just isn't, right? You're on the OTC. There's just not that kind of volume there. You can't
Yeah.
sustain it. So it's not uncommon for a lender to purchase 3, 4, 5 convertible notes in the span of a month or two, and then sometimes also have their friends who are other hedge funds and other lenders do the same exact thing. Say, hey, I just bought 300 grand worth of this guy. He's still probably he doesn't know yet. It hasn't been 6 months. We haven't tanked this thing yet. So why don't you get into
Yeah, and then before you know it, those 3 deals turn into 15 deals, and the
exactly
300,000 turns into, several $1,000,000 later, and the stock is crushed 6 months later, and people are left, holding a bag, and
exactly
worse.
exactly
So,
yeah.
another question in the chat relating to convertible notes, are there time limits on convertible notes? And if so, do they differ from state to state where the company is being held?
Time limits. So I'm not sure what that might be in reference to, but if you're talking about time limits in reference to the amount of the period of time that they last until maturity, maybe. So there's a maturity date on it because it is a note.
Okay.
The maturity date is it's pretty much useless because a lot of these companies don't have the cash to pay at the maturity date, and of course they know that. And anyway, they make the maturity date a year out anyway. They start converting
Okay.
in 6 months. I see statute of limitations in the chat. If that's what they're
Yeah.
talking about, so under 29B, there's technically no statute of limitations for 15A violations. There are statute of limitations in 29B, but they're related to other sections of the Exchange Act, not under 15A. And if you think about it, it makes sense because in the event that a note's void, right? The note's the transaction's illegal. It would
Mhm.
be pretty stupid for the SEC to allow people to walk away as long as they just hold out for 3 years, right, or 5 years. So it's like, oh, it's illegal, but only for this period. No, it's always illegal. It's always going
It's
to be
always
illegal. So
it's
there's
always
no
detect.
there's no statute of limitations. Um, of course, we run into those arguments a lot, but it's not an issue.
Someone else in the chat is asking about online publications, and the example they used is Seeking Alpha. They'll publish articles with little or no relevant information that bashes the stock. What are your thoughts on those?
It is I mean, it's probably just like any other.
Basically, like when a company puts out a short report, we know what the motivation is or the angle that they're going for. Whether it's written in a positive or negative way, someone has an angle with whatever they're putting out there.
Right, of course. Yeah. But of course, like depending on if you're an agent, if it's the company itself speaking or not the company speaking, there are obviously different rules and regulations around that. So, I mean, I think generally, yeah, it's probably like you said, there's probably a motive behind it. But with respect to some kind of punishment, like I said, it's hard for people to get punished for doing things like that, especially as an outsider. That's why I mean, honestly, the Alex DeLarge thing is kind of somewhat surprising because he wasn't even an outsider, but I guess because he was affecting so many people and it was so blatant and right in people's faces, it was something the SEC took notice of.
The person who posted that comment just further made a comment further on their original thought, saying the people writing the articles pay a fee to publish on the website. So there's some motivation. There's motivation behind it with some kind of paywall or pay fee.
Yeah, exactly. Yeah, that giveaway of that, right? You don't pay to do nothing.
So let me ask you about share cancellation. That seems, or share retirement, buybacks. That seems to be a big. I don't even know if catalyst is the right word, but you see companies in the OTC all the time say, "We're eliminating buying back. We're canceling, retiring 500 million shares, a billion shares, whatever the number is." Down the line, the company has to contact the transfer agent. The transfer agent has to then contact OTC Markets. OTC Markets would then update their website with the authorized share, the outstanding share, the float, everything that's on that checklist when you look at a security on the OTC. Let's say 6 months goes by and a company 6 months ago put out, "Hey, we're retiring X number of shares off the count." That never happens. Is there a legal route to go about this? Is that, can a company just put out, "Hey, we're retiring a billion," and it never happens? So obviously the stock goes up for whatever reason. Now, shares are never retired and everyone thinks they were going to be retired and it didn't happen or won't happen. Is there some discourse with this where, shareholders are hopefully can get some money back or something when you see something like this
I would
happen?
say the route for that is also securities fraud. I mean, that's a blatant material misrepresentation if in the event that that doesn't go through, and that's certainly something that would influence a stock price in connection with purchase or sale of a security. So if that's something that's going on, yeah, absolutely, I think that's certainly something that could be pled with securities fraud. But like I said, the same hurdles apply. Securities fraud will always be a very difficult way to recover. So,
Gus, let me ask you, how long have you been at the law firm? And on top of that, after you answer that, what is a typical case like for you at the firm? How does it, play out where retail investor myself or whoever will call you and say, "Hey, I have this kind of problem. Let's sit down and discuss it." And, you go through your background check, you go through your research, you go to your trial or, serving the other company or the security or whatever the reason. What is how long have you been a lawyer? And then on top of that, how does the typical case play out?
Yeah, so I've been here for a little over a year now. The security stuff really is ramped up recently because it's very recent, like I said, with all these SEC enforcement actions. I mean, just I want to say it was like within the last 2 months, the very first dispositive decision on this dealer issue only got issued in June. I think it was June of 2020. Right, so that's very, very recent for other courts to kind of just hop on the bandwagon, and I think that might be a reason for a lot of courts hesitating on making decisions as to the dealer issue. So it is, like I said, like a really new issue, but every day we get updates. So within the last 2 months, that very first case, it's called SEC v. Almagarby. This guy was purchasing a bunch of convertible debt, micro cap convertible debt. And just converting it, right? Doing dealer activity, to toxic notes, same exact thing that all these people do. And he just got hit with a complete disgorgement, huge fine, and the damages were actually written by a magistrate judge, which is technically not the judge. So a magistrate can't enter an order like that, and the judge needs to confirm it or order it. So order it himself or herself. And the judge just so ordered the magistrate's recommendation, which was very, very harsh. A lot of people didn't think that the judge was going to so order it, and the judge made no modifications. So that
Wow.
sent a pretty big wave out to a lot
Yeah.
of people because they're like, "Oh, okay, the judge isn't like they're not messing around. Like this is a huge. I want to say it was like over $80 million he got fined.
Oof.
Or that might have been disgorgement, and then it was like another 10 million in fines. It was a crazy, crazy amount. So I think hopefully soon it's going to be easier to assert these arguments, and courts are going to be more receptive to it. I mean, every day the courts are more receptive to it, but
Mhm.
sometimes these things take time. Like I said, like this Court of Appeals decision, that was I want to say it was 6 years, 7 years of 18, 19 decisions saying get lost, like get lost. Like seriously, it was like almost embarrassing. I mean, we've
Yeah.
gotten it's been brought up to us from other like opposing counsel. Like they brought that up. They're like, oh yeah, cool, good luck. And then all of a sudden the Court of Appeals comes down and everyone's like, oh, wait a second, these guys were right the whole time, right? And it's kind of how we feel. Like we're
Whoops.
like almost always the underdog. But I really think that we have a good position at this point to do it, and it's developing. Like I said, every day. I think that there's just going to be it's going to be a quick, hard, fast turning point. I think at some
Mhm.
point, it might not be for another year, but I think it's going to be hard and fast. And I think all of our litigation that we're going through right now is gonna. I think we're gonna. I think things will pan out, whether it be one way or the other. I think things are going to pan out. A typical case for us, it's like I said, so we don't represent shareholders, we represent companies.
Mhm.
And we assert these rights on behalf of companies because the company is the person who's in the transaction. They need to be in privity with the person who's violating the Exchange Act. Person violating the Exchange Act is the person entering into securities transactions absent dealer registration. So we need to assert these arguments on behalf of companies. The shareholder stuff, that would be a different claim, like what I was talking about before with that class action stuff. That would
Mhm.
be a market manipulation, securities fraud type claim against. It would probably be against a lot of people, whatever. But it's a different substantive claim. So generally, we'd have an issuer contact us. We'd field a call, right? They tell us about all their convertible debt, who they have debt with, whether
Mhm.
litigation's been commenced or not, and they make the decision. Hey, are we going to go after these guys, or are we going to wait for them to come after us? We always recommend let's go. Like let's go after them. Let's not sit and wait. Let's paint the picture
Mhm.
on the wall first. Like we get the first words if we file that complaint as opposed to them getting the first words. And it's very hard to convince a judge to say that somebody just gave you X amount of dollars and you don't want to pay them back, right? Regardless of why. It's hard to
Yeah.
convince a judge of that in any circumstances. But that being said, sometimes when they bring this action, they might have converted $3 million already, and the note was for $200,000. So then in that scenario, it might not be so bad, right? But still, we always like to get the first word in, and
Mhm.
that's in those situations we have a little bit, like I said, a little bit of a different approach on the defensive as opposed to the offensive when we're filing that complaint.
Mhm.
Um, and of course, every single case is different. Even though these notes and these agreements are mostly the same. Sometimes they'll attach warrants in these notes. Um, Warrants are their option contracts, basically, their options. They'll have
Mhm.
an extra strike price and an expiration date, and the holder of the warrant can either exercise or not exercise. A lot of our clients deal with cashless exercises and warrants. Warrants aren't supposed to be cashless. It's supposed to be a gamble. I want the strike
Mhm.
price to be this. I win if the price stock goes up. I lose if it goes down. So it's a riskier investment, obviously, but it could entitle you to have a bigger reward. What a lot of these lenders do is they bury in these anti-dilution or anti-distribution clauses that make adjustments to the formulas and the conversion rates, basically in the warrant, right? So sure,
Mhm.
on the face of it, it'll look like it's a 15-cent strike price. Okay, we never traded over 15 cents. Sure, throw the warrant in, right? You're never going to be in the money. We might be
It's
in the
never
money.
getting there.
You are good for you, and that means we're doing well. We're growing if you're in the money.
Mhm.
But they have this anti-dilution provision, and they know that you have convertible debt, right? Convertible debt triggers the anti-dilution. All of a sudden, you're giving shares out at a fraction of a penny, and all of a sudden, they're allowed to cashlessly exercise 80 million, or, $10 million worth of stock because you had some issuance because another lender put a conversion notice through. And now, all of a sudden, not only are you dealing with your convertible debt, you're dealing with these warrants that have their own derivative liability against you guys with a conversion formula that I can't even, that most people couldn't even begin to describe. Like these math formulas are insane, and the best part is they're always written in words too. right? You could easily just put this in a fraction and use numbers, but they'll never ever do that. It'll only be in words. It's like a word math problem.
It's
And
too easy to see it that way.
yeah,
They
exactly.
don't want you to see it that way.
Right. Exactly. So, depending on the case, it's, we have a slightly different approach, but it's always that main thing is broker dealer. You're not allowed to do this. We're going to avoid this if we're suing you, or you have no rights if you're suing us. So, either it's a motion to dismiss, or sometimes we might assert counterclaims depending on how much damage was done to our client. We'll assert counterclaims, and then we'll move to dismiss under a different rule, and we can dismiss their claims, and then hopefully the only action sustained in the whole litigation is our claims against them, and we didn't even sue them. That's our goal, of course, and we take obviously very aggressive approaches, and we try and we do everything that we possibly can for our clients.
Okay. Another question in the chat that someone is asking, I'm assuming it's what is the cost to open up an investigation? So if someone comes to you and says, hey, we have, this is our issue at hand, is it a flat fee, I guess? The question is kind of vague, so I'm
Yeah. So it depends. So for litigation purposes, I mean, there's not really an investigation, like for like a broker dealer litigation, let's say they have convertible debt, there's not much of an investigation that needs to be done. We know pretty much every player in the game. We know who's doing what and when they're doing it, how they do it, who's behind it, how many other entities that person might have, because they always open up 15 shells and they call them, 1, 2, 3. They'll name it the same thing. It'll just be 1, 2, and 3, as if there's some creative mastermind behind it. As if no one's going to know that you have 7 entities doing the same thing, right? So if you get fined with one, and only that one, whatever. But no, generally our litigation retainer, it depends. Like sometimes we'll work with our clients, but on average, I would say it's we usually reserve about 35 grand for a note, a single note.
Okay.
Depending on what's involved in that note, if there's a shitload of, if there's a lot of warrants in there, we might up that, right? Because it makes litigation a little bit more complex. Depending on what position you're in, if we only need to make 2 filings off the bat, we might reduce that a little bit. If we need to make 5 filings, if the client wants a preliminary injunction or a TRO, then we're going to up that. Our retainer is really going to be based on what services you need right now. And so what are you going to, and we just require our clients to reserve our time for what needs to be done right now. So it's very on a case-by-case basis. I mean, there are some times that there's just not much to be done, and we can charge much less than that. And then there are other cases where we charge much more than that because they want much more done.
Okay. Another question. I don't know if you can answer it or not. It's kind of personal, but do you invest in the stock market? I mean, obviously you're on the other side of things, being a litigation lawyer the way you are, but involved in stocks. But do you invest in it at all? Are you a crypto fan? Are you big cap, small cap? Do you do any of that? I mean, someone's asking, so I'll ask it.
No, it's all right. No, honestly, I'm not smart enough to do any of that. So
Okay.
I let other people do it for
Listen,
me.
you're a lawyer. You passed a couple of tests, all right? You're smart.
So I try and stay away.
Somebody is asking, what's the likelihood of disgorgement in one of these cases, and how long do they usually take to conclude?
Yeah, so disgorgement, I think I mentioned this earlier. I'm not sure if you were paying attention, but disgorgement is a remedy only available to the SEC. Disgorgement is very likely. If the SEC, I mean, you need to see it in the SEC complaint. They're probably going to seek disgorgement in their prayer for relief. So if you look that up and you see disgorgement, and you had shares in that company and you're harmed because of whatever that violator did, then you know that you're going to be entitled to something.
Mm-hmm.
How long it takes a little while. Like I said, like that Amagarby case. I mean, the SEC just takes a while in general, forever. All right, they're going to investigate for a year or 2 years, commence the action. They're not going to miss a step. They're going to do everything perfectly. Execute.
It's not a fly-by-night investigation.
No,
it's not overnight. It's going to be thorough.
It's not. Yeah, they're not going to make any mistakes. And if they're looking for disgorgement, and they probably have enough evidence to get disgorgement, you just need to wait for the judge to order it.
Okay.
But litigation usually takes years. So to answer your question, likelihood of disgorgement, yeah, I think it's pretty likely. If the SEC is alleging it, they don't really allege things they can't prove. How long does it usually take? It's usually a few years, I would say, on average, depending. Sometimes the violator might settle because they know that they're dead to rights.
Okay. I'm just looking at the chat again here. I'm refreshing. One sec. It figures my
Sorry about
computer
that.
freezes here.
In my office so late, they're coming to clean. It's all right.
Like we said before, so Max is asking a question about a specific security. We're not gonna, email Gus and see if Gus writes you back, or ask on Twitter. But we're not gonna talk about a specific security for the main reason of we don't know if Gus's firm is working on a case with or against specific securities or companies. So you're not gonna go there. But people are asking, certain companies have X number of shares and they want to convert. Should they sell? Gus is not going to give you. Buy or sell advice. Sorry, guys.
We could try that.
All right, Gus. I want to thank you for coming on. This was great. I mean, we went over an hour. Very informative. A lot of great stuff. Questions were great by the chat. Thank you for everybody who did submit. If you want to contact Gus, you can contact Gus at thebasilelawfirm.com. That's his email address. On Twitter, it's at GPP_ESQ. The Basile Law Firm, if you want to contact them, their main phone number, like I stated before, is 516-455-1500. Their website is thebasilelawfirm.com. They have offices in New York, Florida, and Texas. And for episode 26 from New York, I'm going to say goodnight to everybody. Gus, thank you for coming on. Have a great night.
Thanks. Have a good night.